matter on the calendar this afternoon. It goes by the designation in re redacted or in re sealed case. It's number 19 SS 1024. As you can see, there are two judges on the bench today. The third judge on the panel is Judge Nebaker. He is listening to the case and watching the argument from afar at the moment, and he will fully participate in the deliberations that follow. In terms of the order of argument, we'll hear first from the service provider, then from appellee, and then from the intervener. And I think we've given each side half an hour, each advocate half an hour for argument. Counsel? Oh, I have one further request. I'll ask you, since this is a sealed case, the courtroom is not sealed, however. So I will ask that you, that all counsel make an effort not to unnecessarily disclose facts that would identify this case. Thank you.
Thank you, Your Honor. I'll do my best. Good afternoon, Your Honors. Joshua Lipschutz from Gibson Dunn on behalf of the service provider. The Stored Communications Act protects the privacy interests of all Americans who use the internet. Social media companies, like the service provider in this case, rely on the Stored Communications Act to keep their users' private information private. As this court explained in the Wint case, the purpose of the SCA is to channel discovery to the people who are actually involved in the communications at issue rather than to social media providers. That way, the affected individuals can take steps to protect their own privacy interests before their communications are disclosed to criminal defendants. In this case, the type of communications that defendant is seeking is unique for the following reason. They are designed to expire, that is, be expunged and deleted after 24 hours. This is a privacy feature that many social media users want. Users like to share things with their friends, but they don't always want their photos of their kids or their vacations living on forever on the internet.
And a recipient of one of these transient or evaporating communications take steps to save it, by copying it, for example?
No, Your Honor, not within the service.
Not within?
Not within the service. In other words, there's always some ability to take out a camera from your phone and take a picture of a screen. There's nothing that anybody can do, but that's true of any private communication. Within the service platform itself, there is nothing a recipient can do to save that communication. The message is gone after 24 hours by design. That is the intent of the sender.
So in other words, a recipient who gets such a message on, say, an iPad or a smartphone, there's nothing on that device that the recipient can use to preserve a picture, for example, of the communication?
Well, I suppose a user could always take a picture, in other words, take a screenshot of some kind. So that's true of any communications that take place, all of our private communications, even when we transmit private information to healthcare websites or anywhere else. There's always the ability to take a picture of a screenshot. But typically when we're looking at the Stored Communications Act and looking to see whether communications are sufficiently private to be protected under the Stored Communications Act, we look within the service. What did the sender intend for the privacy settings to be within the service in which that media was shared? That's what the California Supreme Court said in the Hunter case. The California Supreme Court looked at what it meant to have private communications as opposed to public communications. And what the court said in that case in the California Supreme Court was that where there are truly public communications, where the sender did not configure the message to be private in any way, we can imply that that is disclosable under the Stored Communications Act because we essentially imply consent. And they said, we're not talking about screenshotting or other things that take place off the service. We're talking about, did the sender...
I'm just trying to understand what the expectations of a sender in this particular situation are. The sender knows, for example, that the recipient will have it, so there's no privacy vis-a-vis the recipient. And the sender knows that the recipient has the ability, if the recipient wants to preserve it. Just take a picture. Can the recipient send it on to other people?
Again, not within the service.
Not within the service.
Right.
Okay.
And I think that's important because lots of messages go back and forth across the service. And typically we talk about expectation of privacy in terms of what does the sender expect to happen. And I think any reasonable sender using this service, the expectation is that the message will be gone after 24 hours. That's why these services are popular, and they are quite popular.
I take it, the expectation is it's gone, but it's not gone in the sense that, what, Facebook still has it?
There are certain circumstances in which the message is archived on the sender side, not the recipient side. And because it is oftentimes the sender's message, and therefore the sender owns the content. It is not archived on the recipient side. So if you were to go into the recipient's account, you would not find any trace of the message.
Counsel, could you clarify for me how much it matters to this case that we're talking about something that is designed to be ephemeral? I had interpreted your brief, at least in major part, to say that you don't have to turn this over even if it was long-lasting.
That's correct, Your Honor. It is important in the following sense. Because of the expectations of the sender in this case, and because the recipient who is trying to get access to this information does not currently have access, and I think that's a really important point. This is something that the recipient is trying to get that they don't currently have, and they're trying to get it from someone else's account behind that person's back with the benefit of a gag order from the trial court saying that we're not even allowed to try to get consent from the person who actually has the information. We think that's important because, in our view, that makes this case identical to Wint. Just like in Wint, the person who's trying to get the information from the service provider doesn't have it, has no access to it, and is trying to get it from someone else behind their backs. That makes this case identical to Wint. However, if the court were to find that this case were different from Wint because one of the statutory exceptions applies, as defendant argues, it is then our position, and this is the majority of our brief because we think this is a very important position that many courts have agreed with us on, it is still within the provider's discretion to decide whether to turn over the information. And that's very simply because Congress used the word may. And as this court has held and the Supreme Court has held, may implies discretion.
Let me ask you about your discretion argument. Does that mean that if two different criminal defendants file subpoenas like this, you can choose to comply with one but not the other?
Theoretically, yes, that is within discretion. However, I think the reality is that service providers like my client use certain indicia to decide whether they're going to turn over information in these circumstances. One important indicator is whether the person who's asking for the information has access to it. In other words, whether it's something that that person is actually supposed to have.
So let's assume we have a judgment that as a practical matter, the only way to retrieve the information is through the service provider. You think you still have discretion to deny it to someone?
I think that would be a more difficult case. It's not this case, but I do think the statute still provides the discretion. But importantly, that is not this case. This case, there are alternative means of seeking the information, and in fact, this court in Wint found that to be very significant. The Stored Communications Act does not prevent a defendant from accessing the information that they want. It only prevents the defendant or anybody else from getting the information from the service provider. The Stored Communications Act essentially treats the service provider as if they're not there. They're basically telling litigants, pretend there's no service provider in the middle. Get the information you want the way you would get it if this was a non-electronic communication. Get it from the sender, get it from the recipient, get it from anyone else who has it, but don't go to the service provider because that means that the service provider is being forced to decide whether to turn it over without the benefit of knowing whether the person who has the information wants it turned over. It means that it's done behind the back of the person whose information it is.
It's a little surprising that you find all that in the word may. I mean, none of that appears anywhere else in the statute or in the legislative history. And it seems to me that what's happening here is that the service provider is not being asked to make any discretionary decision. The discretion's been exercised by the court after a hearing that the court has, determined to be sufficiently full and fair and complete. And I have a little trouble seeing why, since you're allowed to turn it over, you shouldn't be ordered to, you can't be ordered to do so. I don't see anything in the statute that precludes that.
Well, we think the word may does indicate discretion. That is what the Supreme Court said in the U.S. versus Rogers
Let me
case
ask-
as well as
yeah,
other
well,
cases.
it depends on the context. Let me ask you the following question. Most businesses, most people have all sorts of records, possessions, things, which the law recognizes they are free to turn over to people or not. They're free to share them or not as they see fit. But if a court orders them to turn it over because because it's relevant to litigation, those people can say, well, I have discretion what to do with this as I see fit, but they still have to turn it over.
That's correct, but in those circumstances, there's no act of Congress where Congress has exercised the judgment. The real exercise of discretion here was committed by Congress. Congress exercised its discretion to prohibit service providers from turning over information in certain circumstances and to permit, using the word may, with their discretion, service providers to turn over information in other circumstances. Respectfully, the trial court in this case doesn't have the authority under the Supremacy Clause to question or change that judgment of Congress. And I think it's not just the word may, Your Honor. The exceptions that defendant is relying on here are the B1 and B3 exceptions under the list. There's a list of 9 exceptions, as I'm sure Your Honors are familiar with. If Your Honor looks at the legislative history of some of the other exceptions, just as an example, B8, which says that a law enforcement agency can ask service providers, a service provider may turn over information to law enforcement agencies in the event of certain emergencies. There is extensive legislative history, including Senate Report number 113-34 at page 15 from 2013, and other places, where Congress was very clear that even if an emergency arises, and this is a quote from the legislative history, and time is of the essence, the bill does not require a service provider to disclose important information to law enforcement investigators. And Congress thought it was very important to give service providers that discretion. Again, that's the same word may, leading to the same list of exceptions.
Counsel?
Same thing with B9.
The parties have cited a lot of cases. Do any of them adopt the position you're articulating to us now?
Yes, Your Honor. Many of them do. In fact, a majority of the courts that have considered these arguments have adopted our position. It's true that
I should be more specific. That because the sponsor of the subpoena has not gone to the sender or the recipient, you don't have to turn it over.
Yes, Your Honor. The Eastern District of Virginia adopted that position in the U.S. versus Wenck case. The Northern District of...
With no disrespect to our neighbor, that's a very thinly reasoned case.
Well, it says flat out, under the Stored Communications Act, a criminal defendant cannot couple user consent and a court-ordered subpoena to compel disclosure from a service provider. That's exactly this case. Northern District of California, Western District of Washington, Western District of Pennsylvania, all have agreed with us.
What do you make then of the exception in subsection 3? Consent of the sender or the recipient. That seems to anticipate a case where you're not getting it from the sender or the recipient, but you can go to the service provider.
That's correct, but the key word in that exception is consent, and it has to be, and it's not just consent. The statute says lawful consent, and the California Supreme Court in the Hunter case that defendant relies on very heavily, they like the part where it finds in their favor on the discretion point, but if you read all the pages leading up to that part of the opinion, the California Supreme Court talks about what it means to be able to invoke that exception and use consent as the means for getting information. And what the California Supreme Court says is that when it comes to privacy protection, the critical inquiry is whether Facebook users took steps to limit access to the information, which they absolutely did here, where they took the step of making sure that the message would expire in the first place. The court goes on. The proper focus is on the user's configuration of communications. The language of the statute makes clear that the statute's purpose is to protect information that the communicator took steps to keep private. So all of that supports our reading of the statute here. There is no valid consent under B3 because the person who is ostensibly consenting doesn't have the materials that they're consenting to be disclosed. Totally inconsistent with even the nature of consent. I can't consent to allow the government to enter someone else's house if it's not my house, even if I used to live there. Completely inconsistent. And respectfully, there's no way to read B3 as being a mandatory exception, while at the same time reading B8 and B9 to be discretionary exceptions, which is exactly what Congress was absolutely clear they intended when they enacted B8 in 2013 and B9 just last year in the Cloud Act.
So maybe the authority of the court is not found in the act, but in the background assumptions of our judicial system, which is there are cases, there are rules for litigating them, there are subpoenas and other forms of compulsory process. And I don't see anything in the Stored Communications Act that absolutely forbids compliance with such subpoenas. In Wint, we said if you don't have an exception to match up with your subpoena, you're out of luck. But here, the appellees at least claim to have an applicable exception.
I will certainly agree with Your Honor that there's no express preemption provision, but the U.S. Supreme Court and this court have held that that's not the final test. This case is a case of obstacle preemption, allowing state courts to force service providers to turn over material where Congress has said that the ability to turn over material is in the discretion of the service providers, stands as an obstacle to the achievement of Congress's scheme.
You know,
And this court can look at the
lots of
Goudreau.
people and lots of institutions would like to claim immunity from judicial process, and that seems to be what your client is doing here.
No, Your Honor, no one is claiming immunity. This is not a provider privilege case, this is not an immunity case. This is a question of what did Congress intend when it enacted the Stored Communications Act to protect people's privacy. The one thing we know for sure that Congress intended was to make sure that people's private communications could not be sought and obtained by third parties who do not have access to those materials behind their backs, without even telling them, without seeing if they consent, by going to the service provider. That's what Congress wanted, and says what it wanted when it enacted the statute. The other thing we know for sure is that there are exceptions on that list of 9 exceptions that are unquestionably discretionary. And I challenge the other side to inform the court how you could read some of those exceptions to be discretionary while others are mandatory when they all start with the same predicate that says service providers may, and then there's a list of 9 exceptions. Congress did not have to write the statute that way. It could have said service providers are prohibited from turning over contents of communications except boom, 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 boom. That's not what they said. They have it's a totally separate section under the heading voluntary disclosure after the prohibition where Congress says service providers may turn over communications under these situations. And it lists 9 of them. Some of them are unquestionably discretionary, and we think, therefore, the court has to read all of them as discretionary. And I would point the court to this own court's decision in Goudreau, which involved service and loan associations, also private organizations, where Congress had passed a statute saying that savings and loan organizations may require escrow payments. That's all Congress said, may. And then the District of Columbia tried to take away that discretion by prohibiting savings and loan organizations from not requiring escrow payments. And this court said, no, that's obstacle preemption. You can't require something that Congress has said is discretionary using the word may. And the U.S. Supreme Court's decision in Geyer involving car manufacturers says the same thing. The U.S. Supreme Court, there was a congressional statute allowing car manufacturers to decide a variety of ways to enact safety mechanisms, including airbags, but did not compel airbags. The state tried to compel airbags, and the U.S. Supreme Court said, no, that is preempted, even though there's no express preemption provision. That is preempted because Congress vested the discretion in the car manufacturers, and therefore the state law cannot compel it. Think of a situation where a state tried to enact a law. Let's take the emergency exception, B8. B8 says, again, as I mentioned, that service providers may turn over information, contents of communications to law enforcement agencies in certain circumstances that constitute emergencies. And Congress is very clear that it wants the service providers to retain that discretion for a number of reasons. One, because it would be, if the service provider were compelled to turn over information in the event of emergencies, first of all, service providers would have to be constantly monitoring all communications to determine whether they have an obligation to turn over communications. And the other thing is that it would give the governments, including, for example, the United States government that you're about to hear from, the ability to simply declare an emergency and therefore force service providers to turn over information. We're seeing this type of activity go on in, for example, FBI versus Apple, where the government declares an emergency and asks companies and tries to force companies to turn over information. Congress didn't want that. Imagine now, under defendant's interpretation of the law, there would be nothing stopping a state from enacting a law saying, in the event of an emergency, any law enforcement agency within this state can require service providers to turn over all social media communications pertaining to the emergency. And under defendant's interpretation of the statute, that would be enforceable, because if the Stored Communications Act doesn't prohibit it, which it doesn't, it gives it in the service provider's discretion, then according to defendants, state law can compel it. That's directly contrary to Congress's intent, and it frankly would not be a good outcome certainly for privacy or for many
Suppose
other
the
reasons.
defendant in this case had gone to the sender and said, we want this material. And the sender said, well, you're not going to get it from me. And the sender says, and the defendant says, well, you've archived it. And the sender clicks a little button and it says, no longer archived. What would you do then?
That would be a classic case of spoliation. The district court, the defendants can go to the judge and get an adverse inference based on that deletion. They can get all the types of remedies that are typically available in any other case of spoliation.
Right, but meanwhile, the evidence is missing. And I'm just wondering whether, under those circumstances, you think that the defendant would go to you and say, all right, well, we can't get it from the sender, but it's certainly not private information. They showed it to us. And I have as much right to that material as the sender does. Turn it over, Facebook, or turn it over, Instagram or Google or whatever. What's the argument against doing that?
The argument against doing that is, first of all, Congress sought to protect people's privacy by giving service providers discretion, and more importantly, forcing parties to use the normal, typical tools of discovery and court remedies for lack of discovery. If this were a letter sent by mail, maybe a Mission Impossible style letter that explodes after 10 seconds, 10 seconds after it's received, you would not go to the post office and try to compel the post office to recreate that letter and give it to you. U.S. law actually prohibits that. We had that conversation during the Wint argument. Same thing here. Congress did not want people going to service providers, either as the first resort or as last resort, and forcing service providers to turn over people's communications. They wanted to take service providers out of the equation so that parties could negotiate their own privacy, protect their own privacy. In any classic case of spoliation, the defendant could go to the court and say, Your Honor, we just served a subpoena on the alleged victim here. They just admitted they destroyed the evidence. We want an adverse inference against the government. We want an adverse inference as to what that message would have said. The government, by the way, could easily issue a search warrant, just as it did in this case, for the sender's communications as opposed to just the recipient's communications, and get access to this information. And if they did that, they'd have an obligation to turn it over to the defendant under Brady.
Does it make any difference to your argument whether the subpoena is a criminal subpoena or a subpoena in a civil case?
It does not, Your Honor. The Stored Communications Act does not distinguish between criminal and civil. And importantly, I think it doesn't make any difference, frankly, to defendant's argument either, which is another problem. It's hard to imagine any case in this country, civil or criminal, where a litigant would not want to go to Facebook or Instagram or Google or any other service provider and say, give me all your information that you have about my opponent, about the witnesses that are going to be against me in court. And if there were a state law permitting them to do that, or a court order permitting them to do that, then according to defendants, the Stored Communications would allow it. That's absolutely not what the Stored Communications Act is designed to do.
Let me ask you a practical question.
Yes, Your Honor.
I know generally that a trial is planned in the underlying case, and don't panic at the premise of this question. Should we rule that the subpoena must be enforced, how long would it take to comply with it?
Should the subpoena be enforced, it would not take long to comply with it. That's not to say, by the way, that there necessarily will be anything to send. We don't stand here telling this court or defendants that we have anything in response to the subpoena, but it would not take long to comply with it. However, I think a far better course of action would be to lift the gag order in this case. Let Facebook do what the statute provides. Let Facebook do what Wint said Facebook should do, or what parties could do, which is try and get consent from the person whose message it actually is, the sender, the alleged victim. Try and see if the government is willing to issue a search warrant for the materials. In those circumstances, the Stored Communications Act provides that my client can turn it over.
Let me press you on part of that.
Yes.
You may or may not know that I'm a recovering prosecutor.
I've heard, Your Honor.
And the idea of a defendant who does not have the power to seek search warrants should go to the government and ask the government to issue a search warrant in aid of the defense seems to me not to be well received, would not be well received.
Well, we've seen it happen in other cases. Either the defendant, or by the way, the court could do that too. I mean, the court could put the government to a choice. Either search for this information that seems to be relevant to the case, according to what the defendants are saying, search for this information, or we're going to, or I, court, am going to either allow some adverse instruction, or I'm going to not allow your witness to testify, or any other number of means that many courts have issued in many other cases. U.S. versus Dockery from the D.C. Circuit, for example. Trial court, the D.C. Circuit said that a trial court can use its discretion to control the presentation of evidence.
This reminds me of this court's decision in Carter, which is about forcing the government to grant immunity to defense witnesses. I'd have to say that I don't view that decision as a unqualified success. It's very impractical.
I understand, Your Honor. I would say that this case is not that case, first of all, but there are lots of cases where evidence is not available to a criminal defendant for many reasons. It could be polygraph evidence that's inadmissible. It could be attorney-client privileged information that would be highly exculpatory, but our privilege doesn't allow it to be turned over. It could be state secrets. There's the U.S. versus, the General Dynamics versus United States case from the U.S. Supreme Court in 2011. Was a state secrets case where the defendant couldn't access information because the government was saying it was inaccessible. And the court put the government to a choice. Either you turn over the information or we're going to have to take adverse action. In that case, they dismissed the prosecution.
You know, what strikes me as very odd about your position is you're not saying this information in this case is privileged, or that it's not information that the government, that a party, the defendant, should be able to get. You're just saying, well, they are able and should be able to get it from the sender or the government, just anybody but us. And indeed, your position is that even though it's perfectly available to those people, or it should be, even though it should be perfectly available to the defendant, if those people don't cooperate, they still can't get it from us. And there's something very odd about that. It seems, I would have thought that if the material is not privileged, and if there's no dispute about the defendant's entitlement to get it, they can get it from whoever has it, whoever it's easiest to get it from.
In the absence of...
And in this case, it's very hard. I recognize that there are some cases where the sender, for example, might have a colorable argument about why, this is private. My privacy is being invaded by your seeking and getting this information. But that's not the case when it's the recipient. There is no privacy anymore. The notion that the sender meant for it to be destroyed so the recipient couldn't keep it, well, that's like somebody putting something in the mail and hoping that, the recipient will destroy the letter after seeing it. They might not. They might preserve it, they might not. But the privacy is lost. Once shown, it's lost. And I just wonder what conceivable policy really is being served. What conceivable federal policy or other policy is being served under these circumstances by saying that the service provider can just, turn its back and say, you either get it from somebody else or you take your lumps, but you're not getting it from us.
A couple of responses, Your Honor. First of all, there is no indication in this case that the defendant is not able to get the information from another source, namely the sender or his representative. So that hasn't even been tried. So before we start jumping to conclusions about what Facebook would do in those circumstances, or a service provider.
But I asked you, it may be that the recipient could get it from the sender.
That's correct, Your
But
Honor.
given that in this case the recipient and the sender are mortal enemies, that seems a little bit unlikely.
Well, but a court can order.
Whether it's easy to do or not, it's hard for me to see why that matters. If that is no longer private information, it is hard to see why the service provider shouldn't be required to turn it over if that's the easiest thing for the administration of justice and the parties to accomplish.
Well, I think that there's a problem with the premise that the court is relying on, which is that there's no privacy interest in this information on behalf of the sender. Let's take a different example. Let's say a sender sends out a post.
Vis-a-vis the person.
Vis-a-vis the person, right. Let's say a sender sends out a post public, no restrictions at all, allows anyone in the world to access it, and then 24 hours later says, you know what? It's a pretty embarrassing photo. I'm going to change my mind. I'm going to retract that consent that I've given, that discretion that I've given, that authority I've given to everyone in the world to access this information. I'm going to change my mind, and I'm going to either delete the post entirely or restrict it to just my closest family members. By the way, this happens all the time. People change their privacy settings on social media all the time. Under this court's hypothetical and defendant's argument, that changing of the privacy settings would be completely ineffectual, that the privacy expectations would be gone forever. Any person in the world could come into court and subpoena and get from the service provider the message that the sender posted inadvertently or purposely to the public for only a brief period of time and then pulled it back. And we'd have to say that there's no privacy in that. I'm sorry?
I would have said any person who received it.
Well, no, because if it was sent to the world, then the addressee ostensibly is everyone in the world. Fine, but if let's say a person sends it out only to their 5,000 closest friends on the service, and then they say, you know what, this is a pretty, I don't want this out there forever. I'm going to pull it back.
Yeah, let's say it's incriminating.
Let's say it's incriminating.
And so a defendant, or it involves a defense that a defendant might have in a criminal case. And so the defendant says, well, I saw it, and yeah, I can well imagine why the sender of that thing doesn't want it out there. But it's too late now, buddy, because I saw it.
Well, but
I want it.
But to allow that person to go behind the back of the person who sent the message originally, give that person no opportunity to even object, even contest that there's a privacy interest, and go to the service provider is exactly what Congress intended. By the way, that's exactly the fact pattern from Wynn.
I think there are good objections that you can make to the gag order, but I'm not sure there are objections that are predicated on the Stored Communications Act. I think there are objections predicated on either the First Amendment or the terms of Rule 17 or other sources.
Well, respectfully, Your Honor, we do ask the court to lift the gag order. We think that's the first order of business. We would like to see if there are alternative means here.
Okay. I'm going to give you a few minutes in rebuttal.
Thank you, Your Honor. I just noticed that my time is up. Appreciate that.
Good.
Good afternoon, Your Honors. William Collins on behalf of the appellee. Denial of appellant's motion to quash should be affirmed because the Stored Communications Act is no obstacle to enforcement of appellee's subpoena. By its plain terms, the Stored Communications Act allows service providers to divulge stored communications to their addressee or intended recipient, and nothing in the statute purports to limit the traditional right to compulsory process or create a privilege against compelled disclosure as the service provider is advocated in this case. The trial court therefore correctly ruled.
How do you respond to the argument that the word may imports discretion? And that what Congress envisioned was that certainly before getting anything from the service provider, one should try to get the communication from the sender.
There is...
Or other entities that might have it.
I'm sorry, Your Honor?
Or other entities that might
Or other entities that might have it. That argument misreads the statute plainly and simply. I believe my colleague to the right said that the way that our proposal to read may divulge to confer permission and not necessarily final authority or discretion would make sense if the statute began by saying, except as provided in the following subsections, disclosure is prohibited. We submit that's exactly what it actually does say. 2702A says, except as provided in subsections B and C, disclosure of stored communications and subscriber information is prohibited as set forth in this subsection. And then subsection B goes on to name 9 exceptions, as my colleague mentioned, and subsection C states other things. But in light of this, the most natural way to read the words may divulge is as granting permission to disclose, not as in giving final authority to withhold, which is what the service provider advocates in this case. The availability.
Well, how do you distinguish the cases Goudreau and Geyer?
Goudreau, Your Honor, I think, so stepping back, I think overall the preemption arguments rise and fall on this notion that the statute was intended to confer discretion, final authority to withhold on the service provider when there's simply no evidence for that in the statute. And that comes from the use of the words may divulge to enumerate exceptions. And that comes from the fact that Section 2703 is not an exhaustive listing of the circumstances under which disclosure can be compelled, but rather just a enumeration of and limitation on the government's ability to access information. So if you don't get to service provider has discretion, there is no conflict preemption to be had.
What you just said sounds to me like an argument that Wint was wrongly decided. I understand Wint to say that the subpoena is ineffective unless there is an exception in the statute that you can couple with it.
We would agree 100% with your reading, Your Honor, and we're advocating no more. We're saying that because there is an exception, the prohibition in 2702A is inoperative, and the statute doesn't compel service providers independently to disclose under the circumstances enumerated in 2702B, but doesn't prohibit them. And the subpoena power exists separate and unto itself, and this statute was enacted with that in mind, which I would remind the court, the subpoena power in this case is derived from statute, the Court Reorganization Act, which mandates, passed by Congress, which mandates that the courts of the District of Columbia apply the federal rules of criminal procedure.
Is there a partial preemption? If Wint is correctly decided, then doesn't the Stored Communications Act limit the force of a subpoena?
That's correct, Your Honor. And it's fair to characterize that as partial preemption, if you will. But that depends on express language in 2702A, which makes it verboten to disclose except under the circumstances enumerated in 2702B. And those were, that in a nutshell was the holding of Wint. Subpoenas aren't another part of 2702B, therefore they don't get their own exception. But when there is an exception that applies, and there is, and the trial court, or there's a separate authority to compel disclosure, there's nothing in the statute that says that can't happen. And I wanted to comment briefly on the hypothetical proposed by my colleague that reading the statute in the way that we propose, reading may divulge to confer permission and not final authority to withhold, would give the government carte blanche to declare an emergency. That we agree that shouldn't happen, but there seems to be a very simple answer for why it can't, which is 2703, which enumerates exhaustively how the government may require service providers and providers of remote computing services to disclose stored communications and non-content information. So again, nothing in 2703 purports to state everything, every circumstance under which a provider can be compelled to disclose. It's about what the government can do. The original title requirements of governmental access further illuminates that. We've cited portions of the legislative history, and I won't bore the court with that.
Why did the defense here not go first to the sender?
To the sender?
To the sender, to get the information.
It wasn't necessary under the statute is a very simple answer, but apart from that, there are strategic and confidential reasons and reasons related to the individual facts of this case why it wouldn't have been prudent. But I think in any case where you have a criminal defendant seeking records from the complainant, as Your Honor mentioned, there is likely to be some animosity around that, such that we wouldn't have any reason to think it would be availing. And I guess apart from, well, let me backtrack. As Your Honor correctly stated, the best evidence of what is in the records we seek is on a server that's held by the service provider, and there arise spoliation concerns when you introduce the sender's files, and there arise willingness to disclose issues when the sender is introduced. And going to the government is a non-starter for reasons that Judge Fisher, you very eloquently illuminated. It's just not what you do. To show your hand to your direct adversary at trial and say, please, can you help us, when there doesn't appear to be any authority to compel you to do so.
Well, why do you think the gag order in this case, if we can call it that, was appropriate and consistent with not just the First Amendment, but just general norms? I mean, if the, normally when one goes and talks to witnesses, you can't tell the witness, and you can't get a court order telling the witness, don't talk to the other side. A witness who goes into the grand jury can't be told, don't talk to the defense. Why is it that the gag order in this case was appropriate?
Well, as Your Honor stated in resolving the prior appeal, I think the interest that the provider has expressed in communicating in this case, specifically on the record, was to negate the subpoena that it viewed as unlawful. And this
Why does that make a difference?
So we've cited cases that suggest or that note that the public or private nature of the nature of the communication does matter in terms of the First Amendment, Your Honor.
Let's put it differently. How would the defense have been prejudiced if the provider here had gone to the victim, the complainant, or to the United States? I don't know what they could have said to the United States consistent with the Stewart Communications Act, but maybe they could say something, I don't know. How would the defense have been prejudiced? The provider has made it clear we're not going to let this information be destroyed.
Your Honor, given the provider's position that the first thing that they would like to do, once Your Honors decide this case, depending on how it goes, is go to the government and see if they will obtain a warrant.
The government's going to hear about it if the subpoena is enforced, as I understand the court's order, and for that matter, Rule 17, the government would learn about the evidence.
Yes.
And if the government learns about it, the complainant will too.
Both those things are correct, Your Honor. I would rest on my briefing with respect to this, Your Honor.
So the value you're serving is a head start?
I don't think that's not an accurate way to characterize it, but again, if the court is inclined to, I would rest on my briefing with respect to this.
Well, let me press you a little further. The order requiring the service provider not to reveal this has made our job extraordinarily difficult. And maybe those difficulties are necessary, but I'm inclined to think that trial tactics are interfering with our interpretation of the statute, or our ability to interpret the statute fairly and accurately. And so, I know you referred to your brief. Is there anything else you want to add about why the so-called gag order is appropriate here?
The order is set to expire upon compliance with the subpoena. I think that's consistent with the understanding that Rule 16 would eventually require disclosure of this information upon receipt by appellee.
Let me try it this way. Assume hypothetically that we rule that the subpoena should be enforced. So you essentially win. That seems to portend that all future litigation will be conducted with similar gag orders. And I'm not eager to go through that again.
With due respect, Your Honor, we submit on the briefing with respect to this issue.
All right, let me get back to the question of the interpretation of the Stored Communications Act. The basic theme, as I understand it, of the service provider is that Congress meant in 2702B to basically channel discovery to the parties with the interest directly at stake, the senders of the communications and the recipients of the communications, the users, rather than to have the service provider even be involved in making those decisions. Now, of course, Congress did that in a very elliptical way. They could have made that a lot clearer, right? But that's the theme. How do you respond to that? It seems on its face like a reasonable position. Why shouldn't the people whose privacy is actually at issue be the ones to litigate, if there's going to be litigation, over the disclosure of their communications?
I think Congress correctly balanced the interests at stake when it articulated the various exceptions under 2702B, one of which is operative here. And
This turns on how we interpret that.
it turns on how you interpret it, Your Honor. But there's every indication that it intended for disclosure to an addressee or intended recipient or that person's authorized agent or with the consent of such a person to be a sufficient exception to the prohibition on disclosure unto itself. And there is ample language in the legislative history to indicate that subsection B and the addressee or intended recipient exception specifically was a balance of the privacy interest at stake by Congress that the service provider doesn't give Congress credit for balancing.
Well, there is something funny about the discretion argument, I guess, which is that, taken literally, the argument allows the service provider, if it, woke up badly that day or whatever, to turn over and disclose all sorts of stuff without telling the sender, for example.
Without interrupting, Your Honor, I would add this could create a patchwork of different policies by different service providers and no uniformity regarding who may or may not be an addressee or intended recipient.
Right. How do you respond to the hypothetical example given of the person who posts sort of indiscreetly an embarrassing post, to the world? I don't know how this works, but, and 24 hours later wakes up, is no longer drunk, and takes it down and says, oh my God, hopefully nobody's gonna ever see this thing again. And then, somebody gets wind of it, and next thing you know, the service provider has a subpoena for the thing. How do you think that should work?
There are layers of protection embedded to the subpoena that the service provider does not acknowledge in this litigation. That piece of information, that post, that embarrassing post, if relevant and material to litigation as contemplated by the U.S. Supreme Court in Nixon, should be subject to disclosure with ample protections for privacy, such as in-camera review that could keep it from being disseminated widely, and an opportunity for all to be heard with respect to the potentially privileged or private nature thereof. But as Your Honor has correctly stated, we're dealing in this case with a communication that was sent to appellee and in which there is no current privacy interest. And to the degree that there was some privacy interest at stake, the trial court correctly recognized it and imposed a requirement for in-camera review as to non-content information. So we've tried to respond to these sort of policy arguments in the briefing by stating generally these aren't absurd results. The subpoena process has protections built in including generally for notification, although the trial court made the finding in this case that notification wasn't required due to the nature of the request. And those are ample and sufficient to protect privacy interests in stored communications, which, yes, sorry.
So if I've understood you, you're saying those safeguards, those protections are not found in the Stored Communications Act, but they are found in the essential jurisprudence relating to issuance and enforcement of subpoenas.
That's correct, Your Honor. And much more well said than I did. We are the addressee or intended recipient of this communication. The plain language supports that argument. Addressee, the person marked, one to whom the transmission is addressed. Intended recipient, one whom the sender intends to take delivery. The service provider's argument conflates the idea of consent to retain and intent to receive. Intent to receive is done when it is sent out for delivery. Setting apart the policy arguments, which I think we've responded to by noting that there aren't sort of residual privacy interests, as Your Honors have noted, it's just the plain text of the statute. The addressee or intended recipient is the person to whom you send the thing, regardless of whether you intend for them to keep it. And it's like Congress could have said, could have allowed for disclosure based on the consent of the addressee or intended recipient, provided that the originator also consents, but we don't see anything like that. We have two separate, B1 and B3, two separate exceptions.
Yeah, by the way, how do all these arguments play out with regard to the aspect of the subpoena that seeks not the contents of a communication, but the other data on communications, the records of communications, which any person, which the provider is permitted to disclose to any person? Are there privacy interests at stake with respect to that data?
There may be. We think that they can be. So I guess I have two answers to this. One is that nothing in the Stored Communications Act requires service providers to provide that non-content information to anyone other than the government. It's just that they may disclose it to anyone other than the government. In that regard, I think we are.
The subpoena calls for that information in this
And
case.
if the subpoena calls for it because it's relevant and material to litigation, or because, I think as Your Honor mentioned, Judge Fisher, there are circumstances. This isn't just about the service of process. This is about the court's ability to order, in any case, for any reason, including to satisfy a judgment, the production of contents and non-contents from service providers. But that's a digression. This 2702C reflects a thoughtful balancing of the privacy concerns and allows service providers to disclose, won't penalize them for disclosing, essentially. And it is on the court who issues a subpoena for such information to balance the potential privacy risks and, at the urging of the service provider or any interested party, order in-camera disclosure, order other protections to prevent people's privacies from being invaded unnecessarily.
Why do you think Congress in the Stored Communications Act did not address this whole area of discovery requests, call it broadly, subpoenas and other discovery requests, for information from service providers in civil and criminal litigation? Nothing in the legislative history about that, nothing in the statute about that, except where the litigant is the government. Why do you think this is an area of complete silence?
It was taken as a given, Your Honor. I think the power of courts to compel property and compel things to their courtroom was sort of well understood, and there was no need to sort of clarify or enunciate or write into the law something that everyone already knew was happening. There is a great deal of specificity with respect to the government and its ability to require production of contents and non-contents, because that was clearly on the minds of the people enacting this legislation. They wanted to fill a gap left by the Wiretap Act, which doesn't mention stored communications of this kind. And limiting the government, constraining the government's ability is an intent that is present not only in 2703, but also 2702A3, 2702C, and 2705 through 2704, 05, and 06.
So
Those
your
are all,
argument, so your argument comes down to, you see, the argument can be made by each side in its own way. Your argument comes down to when Congress wanted to prohibit something, prohibit some discovery, they spoke to it directly. And anything not prohibited is permitted. Any discovery that's not prohibited is permitted. Now, the service provider can turn that argument exactly around and say that when Congress wanted to allow and require something, the service provider to provide information, they said so, and when they didn't say so, they're not required to do it. It is an odd gap in the, and it's not like, they could have been ignorant of this possibility. In fact, the very fact that they talked about government exercise of discovery to get things suggests that they were well aware. Now, maybe that's a point in your favor. But it is a very odd gap.
Perhaps not so odd, Your Honor. And the Fourth Amendment looms large here, and the right to every man's evidence, as it was phrased, and I believe U.S. versus Nixon also looms large. So that even if Your Honor feels that this is sort of, there are odd gaps on both sides and we're not sure what to do, I think the presumption against implied repeal of the compulsory process right would break that tie, certainly. And the notion that when Congress wants to withdraw, sort of recede the very well understood right to access evidence by either side, they do so clearly, they indicate clearly and strongly.
That's what we said in Wind and have said in other cases.
That's correct, Your Honor. And so if the court has no further questions.
And we'll give you a few minutes for rebuttal after. Oh, wait, no, I take that back. You're not responding to the United States. So.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. Andrew Lang for the United States. The best interpretation of the Stored Communications Act is as permitting service providers to disclose information that falls within one of the exceptions, not as necessarily allowing service providers to refuse to disclose such information, even in the face of compulsory legal process. I'm also happy to talk about the constitutional issues that defendant raises. The bottom line is that although we don't have all the factual information we would need to take a position, the bar for defendant would be set very high to show a constitutional entitlement that trumps a statutory privilege, and we don't think, in any event, that a constitutional entitlement would flow from the Confrontation Clause. Turning to the statutory interpretation issue, the threshold question that I think everyone agrees on is whether defendant falls within one of the exceptions at B1 and B3. That is to say, whether defendant is an addressee or intended recipient of these communications. I do want to clarify, I don't think the question boils down to any notion of consent. B3 says contents can be disclosed with the lawful consent of an addressee or intended recipient. And I don't think there's any dispute that if defendant is the addressee or intended recipient, then defendant could consent to disclosure. The consent discussion in Hunter, I don't think really has any relevance to the statutory interpretation question here. Hunter is about when a post is made available to a large group of people, whether or not that is tantamount to consenting to disclosure to the general public. And that's not at all the question that I think this court is facing, whether or not defendant is the addressee or intended recipient of these messages.
Let me ask you about the consent provision. I'd been inclined to think this was all about exception number 1, but what's wrong with the analysis that by requesting this subpoena, the defendant in this case, an intended recipient, has consented to disclosure under B3.
I think that's true. I think the defendant has expressed consent to disclosure, but I don't think it matters to the analysis here whether or not service provider is nevertheless entitled to refuse to disclose. And in my view, the service provider's argument is the same under B1 and B3. Even if defendant fits either or both of those exceptions, and in our view it's probably both, then in their view, service provider could refuse to disclose even in the face of a subpoena. So assuming defendant is an addressee or intended recipient, which may turn on some facts that we just don't have, the larger question is whether service provider can nevertheless refuse to disclose despite the subpoena. And there are a number of reasons why the statute gives permission but doesn't necessarily confer discretion to refuse even in the face of compulsory legal process. The first reason why that interpretation is correct is the text and structure of the statute itself. First of all, while we agree that may often confers discretion, it doesn't necessarily confer discretion. And the unanimous opinion of the California Supreme Court in Hunter is very well reasoned on this point. May divulge in B and C of Section 2702 introduces exceptions to the general prohibition in 2702A. It means generally you're not allowed to disclose, but under the following circumstances you are allowed to disclose. It doesn't necessarily mean you can always refuse. It simply permits disclosure in the face of an otherwise sweeping prohibition. The other problem with interpreting may divulge as always meaning discretion to refuse is that several of the subsections in 2702B and C in fact require disclosure. 2702B2 refers to 2703, which spells out a variety of circumstances under which the government can require disclosure. 2702B6 refers to the National Center for Missing and Exploited Children, and that statute itself requires disclosure under certain circumstances. So if may divulge necessarily meant may refuse to divulge, then the statute would at worst be nonsensical, and at best—
Why is that? I'm not sure I follow that. Why is it one can't read the statute as saying, you know, you have discretion to divulge in the following circumstances, and by the way, in some of them you have to divulge. You know, and if we don't say you have to divulge, then you have discretion to divulge. I mean, I'm not saying the point you're making is completely without force, but I don't know why it's all that probative on the issue.
Well, for the following reason. The argument that service provider makes at pages 9 and 10 of their opening brief is that may divulge, and particularly the word may, means discretion to refuse. That introduces each of the 9 exceptions in B and all of the exceptions in C.
If I could interrupt you, I guess what I'm saying is that it may be that discretion isn't the perfect word here. Suppose we just understood it to mean here's a set of circumstances in which that absolute prohibition doesn't apply. In some of them you have to disclose, and in some of them it's your choice.
Because I think we have an obligation to read may divulge as—
May covers all that.
Well, I'm not sure that it would, because if may divulge means, if the word may in the prefatory clause in 2702B means may refuse, then it would be at best a little contradictory to have 2702B2 and 6.
This is not a super well-written statute. You would agree with that, right?
I don't
you don't have to agree with that.
I don't think it's ambiguous on this point. I won't take a position with respect to the SCA generally, but on this point, may divulge is best read as conferring permission. I do think one characterization in service provider's brief is apt, and that's the following. May divulge confers permission to disclose, and another source of authority might separately require disclosure. That's exactly what the subpoena does. The subpoena separately requires disclosure where an exception permits disclosure. And that's the most straightforward reading of the Stored Communications Act, and it avoids this tension where may divulge would have to mean something different with respect to different subsections.
Unless, as the service provider argues, an external requirement imposed by a state or by possibly other sources disclose is inconsistent in some way with, and therefore preempted by, Congress's structure here. And I think, if I understand correctly, the service provider's argument is that we have that sort of inconsistency here because Congress's basic goal in this area was to channel discovery disputes to the parties who actually have the privacy interests at stake. Now, if I've roughly stated correctly the proposition that's, yes, the proposition that's being put forward, how do you respond to that?
So I think the preemption argument really rises and falls on the idea that what Congress was trying to do in the Stored Communications Act was give service providers discretion to disclose or not to disclose. And I don't think that that's what the statute does for all the reasons we spell out in our brief.
Is there any evidence in the legislative history, well, I can't think of where else to look, that Congress intended to give that kind of discretion to the service providers?
Not that we're aware of. And the portions of the legislative history that we quote in our brief suggest, at most, that Congress thought it was doing what we read the statute as doing. That is to say, creating exceptions to a general prohibition, not necessarily
So
conferring
why do you
discretion.
think that Congress remained silent on what must have been, you would think, an obvious issue, which is whether this kind of information in the possession of service providers could be subpoenaed in civil or criminal litigation?
Well, I don't know that Congress saw it as necessary. I hesitate to divine what Congress was thinking, but I think the statute speaks for itself. Service providers generally can't disclose, and as this court said in Wint, under 2702A, if something can't be disclosed under the SCA, then it also can't be subpoenaed, and the subpoena is preempted under those circumstances. But service providers are permitted to disclose under the following enumerated circumstances, and there's no barrier where disclosure is permitted to the enforcement of a subpoena like the subpoena here. So I agree that Congress doesn't speak explicitly to the issue of a subpoena or other compulsory process, but again, in our view, the statute speaks for itself. Another important conflict that this interpretation—
May I ask you a question? Do we know the genesis of this statute? I mean, in other words, if one were to go back in history and look at who's the first person to put pen to paper to draft this thing, and how did it progress from there? Do we know that? Is this like an industry statute that was, foisted on the government by, a consortium, or is it some sort? I'm just wondering how this got to be the way it was.
That's a larger question that I think I'm prepared to answer. I take service providers' point that I think in the 1980s there were some concerns that federal law was insufficient in its coverage of burgeoning electronic services like electronic bulletin boards, things like that. So whether and under what circumstances stored communications by online, I hesitate to even say online, service providers in 1986. But at that time, there was not a statutory scheme that governed those communications. But as to your larger question about who was motivated to draft it, I'm not sure I'm prepared to answer. I do want to make another point about a legislative conflict that our interpretation of the SCA avoids, and that is with the Telecommunications Act. The Telecommunications Act, under certain circumstances, requires the disclosure of non-content information upon customer request. If service provider were correct that may divulge meant may refuse to divulge, then a service provider could point to the Stored Communications Act at 2702C6 and say, well, I may divulge non-content information, so that means I can refuse, but at the same time be bound by the Telecommunications Act to divulge the information. And the simplest way to avoid that statutory conflict is as interpreting may divulge as simply permitting disclosure, not, again, requiring service providers to be able to say no.
Does that add anything to the conflict you pointed to that is within Section 2702B, namely that there are some subsections of that refer to required disclosures?
In our view, it's an additional and different problem.
Why is it? I'm missing the point why it's different.
So they're caused by the same interpretive issue. They're caused by the same interpretation of may divulge. Both of the interpretive roadblocks that our interpretation removes are caused by interpreting may divulge as necessarily conferring discretion to refuse to disclose. So in that sense, yes, they are the same problem. But the Telecommunications Act conflict, I think, is also relevant for the additional reason that it's outside the four corners of the Stored Communications Act. So it further undercuts service providers' argument that where Congress wanted to require disclosure, they said so specifically inside the four corners of the Telecommunications
So
Act.
do you draw an analogy between the Telecommunications Act, which is outside the SCA, and federal and our Rule of Criminal Procedure 17, which is outside the SCA? Is that a correct analogy from your point of view?
Yes, I think that's perfectly fair, because under both circumstances, we would have service providers saying may divulge means I can refuse even in the face of either the subpoena or the Telecommunications Act. But interpreting may divulge as merely conferring permission completely avoids any such conflict, either with the Telecommunications Act or with the subpoena. I think defense counsel touched on the principle that exceptions from compulsory process are not lightly created nor expansively construed. Certainly, if there is any ambiguity in the statute, that principle is an important one. I know service provider doesn't characterize this as a service provider's privilege, but under certain circumstances, that's exactly what it is. It allows service provider to point to the statute and resist compulsory legal process. And we should expect Congress to be explicit when it creates a privilege like that or a privilege by any other name.
Let me ask you a question related to the constitutionality of the Stored Communications Act. As the service provider pointed out, there seem to be a lot of district court decisions which essentially agree with the position taken by the service provider, that the act does not permit a defense subpoena. The act has been in existence for more than 30 years. You would think those rulings would have generated a number of arguments on appeal that the act as so applied is unconstitutional. If so, those cases have not come to my attention. Are they out there?
Not to the government's knowledge, not that speak to this exact issue. I don't have an explanation as to why. It may be that some of these services, and particularly the notion of expiring messages that the recipient can't access himself, that concept is relatively new. So that may partly explain the dearth of case law. I do want to make a point on those cases, though. The service provider has cited 4 district court opinions, none of which is particularly well-reasoned, with all due respect to those cases, and none of which engages with any of the argumentation that we've been talking about here, the meaning of may, the conflict within and outside the Stored Communications Act. And it's also worth noting, as we cite in our brief at page 23, there are quite a few district courts that have come out the other way. District courts that have said, well, if you have a subpoena that's for some content that can't be disclosed under 2702A, and some non-content that would fall within 2702C6, then the subpoena is enforceable to the extent that it's for information within 2702C6. All of those district courts have essentially read the statute the way that we do. May divulge means as long as it's within an exception, there is no obstacle to the enforcement of the subpoena. So I don't know that a majority of courts or a large number of courts have come out one way or another, but there are quite a number of district courts who have held that subpoenas are enforceable for information that falls within a 2702 exception. With respect to the constitutionality of the Stored Communications Act, I think the analysis would be largely the same as what this court undertook in Wint, whether defendant really has alternative means of getting at the information, and how important it is to the defendant's theory of defense. That's a relatively high bar. There are factual nuances as to which we don't have the information that we would need to comment. And I think we've made clear in our brief that our view is that if there is a constitutional entitlement to this information, notwithstanding the Stored Communications Act, then that wouldn't flow from the Confrontation Clause, because that's not about pretrial discovery of documents. To the extent this court has any other questions about the Stored Communications Act or the constitutionality, I'm happy to answer them. But if not, we ask the court to affirm.
Thank you.
Thank you, Your Honors. Quite a bit of discussion about the privacy interests of the sender here, the victim. There's somebody missing from this room, though, and that's that person, the victim. They're not here. Why are they not here? For a number of reasons. One, because defendants in this case and in lots of other cases don't want to serve subpoenas, don't want to serve process on the person who could stand up and protect their own privacy interests. They'd rather take the easy route, that's my colleague's word, the easy route of going to the service providers and just trying to get whatever they can from the service providers behind their backs. That's what the Stored Communications Act, and I've said this a few times, but that's exactly what the Stored Communications Act was intended to prevent. The person whose privacy interests are potentially at stake, whether or not they ultimately have privacy interests in these communications, is something maybe a court could decide, but certainly they should have the right to be here. And so to gag my client and prevent them from even trying to involve that person in the proceedings, to go, what litigant would not take the option of going directly to the service providers every single time? Why would you ever go to the sender or recipient of the communications?
I think if I were a litigator still, I would go. I might well think, gee, I'll go to both, frankly, because who knows if I'll get everything to which I'm entitled from the sender in any event, even if the sender purports to give me stuff. In this case, though, if we just focus on this case, it's a little hard for me to imagine what argument the sender here could possibly make to justify not turning over the sought-after material.
Well, the sender probably, if they're subpoenaed, often they might have to comply with the subpoena, but they would get up and at least have the ability to argue, I didn't intend for this to go to the recipient. I set it to expire. I didn't want him to have access to it.
But I think none of those arguments would work, I think. That's what strikes me.
So does that mean we deprive the person of the ability to make those arguments?
No, I've already made clear, I think there's a serious issue about the gag order, but I don't think it's an SCA. I'm not persuaded it's an SCA issue.
If I could take a few moments, I know I'm limited on time. Senator Leahy, by the way, introduced the first bill in 1985. It was passed in 1986. Representative Kastenmeier was the sponsor in the House. This was long before this industry, my client's industry, even existed. Most of the service provider CEOs were in elementary school at the time. But this bill was, exactly as the government pointed out, designed because there was viewed to be insufficient protection for electronic communications vis-a-vis the government or other people that might want to seek them from the providers. And that's because of the third-party doctrine and other doctrines that Congress was concerned would not be applicable to electronic service providers. So the point of the bill, as stated at length in the legislative history, was to protect people's privacy, but also to encourage the development of novel technologies and help people feel comfortable using what was then an emerging technology, and to prevent the electronic providers from having this burden of being this constant repository of information that litigants could go to in every case and get people's communications. That was if you go through the legislative history.
Doesn't sound like much of a burden. When Judge Fisher asked earlier, if it turns out that we end up enforcing the subpoena, how long would it take you to provide the information? Your response was not long at all.
That's because we've already done a lot of the searching. It is quite a burden, Your Honor, to go back and try and reconstruct these communications. Now imagine doing that for every criminal defendant in every case across the country, not to mention civil litigants. Again, why would you not?
When you say that's because you've already done the searching, I was under the impression that maybe I don't know where I got this impression from, that you had not done that.
We have done the searching, Your Honor, but we have not revealed whether there is anything to respond to the subpoena.
Have
because
you
in our view,
reviewed the material?
we have, Your Honor.
Oh, so if there is any material, so you've reviewed what there is to review, in other words.
Yes, Your Honor. I'm not saying we're definitely finished, but we've at least undertaken that task, yes. But I don't think it would be fair to expect us to reveal whether there even is anything in response to the subpoena unless this court
Are there any circumstances in which you might not have the material, but the victim would, the sender would?
Absolutely, Your Honor, sure. I mean, if certain things are deleted from their account, it might be expunged entirely from even our records, but the victim might be holding on to the message for whatever reason. They might have a separate copy of it on their own hard drive. So absolutely. If I could take this court for 1 minute through the exceptions, I think it would be helpful because we've heard from both of the arguers on the other side about how the Stored Communications Act is a comprehensive statute, which, by the way, is one of the key requirements for obstacle preemption. And we heard from the government that the exceptions all have to rise and fall together, that the word may is the same across all of the exceptions. That's my argument. And I think it's really important that your honors look at the list of 9 exceptions, because look at, for example, section B4, which is an exception that allows service providers to divulge the contents of communications to anyone employed by a service provider. Is it really possible that Congress meant for every Facebook and Google and other employee to have the ability to go into court and seek anyone's communications by subpoena? Because if that's the argument we're hearing on the other side, is that any of these exceptions coupled with a subpoena.
Why wouldn't, well, there's a step you've left out. I mean, why wouldn't the answer to that be that, yes, the person employed can go into court and try to persuade the court that what this subpoena calls for is relevant and not too burdensome, and all the other requirements that have to be met under, if it's a criminal case, Rule 17. In the example of a person who's just an employee, there'd be a big suspicion that this is a complete and utter fishing expedition, but presumably the court would say, well, I'm not enforcing that subpoena.
Employees are litigants of cases all the time. There are lots of
Sure, and
employees.
if they can show that the communication is relevant and necessary, whatever the standards might be in a particular case, why can't they seek a subpoena?
Because that's a lower bar because why would employees, just by virtue of B4, be uniquely allowed to go seek a subpoena where other people would not? It doesn't make any sense. And it would make the bar for them even lower than for the government. That's not typically how investigations work. The government has the ability to, with probable cause, to go in and get search warrants and search records. We don't typically give defendants the same rights as the government, but actually give them a lower burden, just a mere subpoena burden, to go get documents or search people's houses or other things. Take exceptions B8 and B9. B8 and B9, we heard on the other side said that there's no legislative history speaking to discretion, but that's just not true. B8 and B9 are 2 exceptions that were enacted more recently than the Stored Communications Act. B8 was enacted in 2013. B9 was enacted just last year as part of the Cloud Act. And there is express legislative history with respect to both of those exceptions that talks about why it's important that those exceptions are within the service provider's discretion. I pointed the court to the citation earlier for B8. If your honors look at the B9, the Cloud Act, there is a statement by the DOJ, by the same party that you just heard argument from, saying that, quote, there is no requirement under U.S. law that a provider comply with a foreign order, and the Cloud Act creates no such requirement.
B9, it's interesting, B9, you're right, does not say anything specific about the provider's druthers. B8, though, does seem to provide some discretion and provide for it explicitly. And of course, the government and defendant rely on, or cite most specifically B6, where there is a requirement in the statute that's cited, right?
Yes, but every time the list of B1 through 9 exceptions reference a provision that requires the disclosure, it actually references the provision. So B2 references a number of other provisions that create the requirement. Nothing in B2 creates the requirement, it authorizes it. Same thing with B6, which references another statute. So those are statutes that are actually referenced by the list of exceptions that themselves compel the disclosure. That doesn't change the voluntary nature of the disclosures in the list of 9 exceptions within 2702B, and there's no conflict there. They're permitted, the service providers are permitted to disclose under the list of B exceptions, but then by some other federal statute are required to.
Well, now, Federal Rule of Criminal Procedure 17 has the force of federal law too, right?
Not as operated by the DC courts. That is, it has the force of state law.
Well, actually, the federal rules by statute, by enactment of Congress, are our rules. So, in effect, the fact that it's a federal rule may have some bearing here.
Well, I think this would be a different case potentially if this were a federal subpoena, but because it's a state court, effectively a state court subpoena, this court has held in other cases.
Suppose this were a federal district court.
I think that it may turn out to be a different case. We don't know. That's not this case, because then you'd have a conflict between two federal laws, which is not typically when we talk about preemption.
That's why I asked about the analogy, if it is an analogy, between the Telecommunications Act and Rule 17.
Right. The Telecommunications Act is a federal statute, by the way, later enacted than the Stored Communications Act. It was enacted much more recently than the Stored Communications Act, and it's very specific to telephony data. So I think if there's a conflict between the Stored Communications Act and the Telecommunications Act, two federal statutes, courts would employ normal procedures of statutory interpretation and decide which of those statutes governs the particular conduct. That's not what happens when you have a conflict between a federal statute and a state court ruling, like we have in this case, where principles of preemption apply.
Well, how do you respond to the argument that the existence of a conflict depends on an interpretation of the Stored Communications Act that is by no means a given? The act is at best rather ambiguous on this very question, and there's nothing in the legislative history that indicates that Congress gave it any thought. And if they had given it thought, one would have expected that the statute would be more specific than it is, and that under those circumstances, the default rule articulated in Wint and elsewhere is that there is no restriction on the enforceability of federal process.
I would point out that this court considered that same argument in Wint itself and rejected it and said specifically that although, quote, although the SCA does not specifically address criminal defendant subpoenas, it does specifically and repeatedly address disclosures in response to subpoenas and other court orders. Congress thus necessarily considered the issue of disclosures based on court orders.
The difference is that there, Wint was talking about the operation of a specific prohibition, whereas here, we're talking about the operation of a exception.
Understood, Your Honor. I was simply responding to the point that Congress somehow didn't consider or forgot about criminal defense subpoenas. That was rejected by this court in Wint, granted for potentially a different purpose, but that particular proposition was rejected by the court in Wint. And I would point this court to Murray versus Motorola. Last case I'll cite, Murray versus Motorola, DC, this court's decision from 2009, where it talked about obstacle preemption and talked about statutes that strike, quote, a proper balance, where Congress has made a balancing test and determined what the proper balance is. And when state statutes are preempted, when they alter that balance. And I would say that in this case, it is simply not true that the statute doesn't speak to this. The statute does speak to this. Representative Kastenmeier, the sponsor of the statute, said very plainly, 132 Congressional Record H4039-01, today Congress stands at a crossroads with respect to electronic communications privacy. We may provide the forum to balance the privacy rights of citizens with the legitimate law enforcement needs and other interests. And Senate Report 99-541 says the same thing. The SCA strikes, quote, a fair balance between the privacy expectations of American citizens and the legitimate needs of law enforcement agencies. And for this court or the trial court to upset that balance under a state court rule is preempted under Geyer and under Goudreau and all the other cases that I cited earlier. And so we would ask this court to reverse the lower court's decision.
Final question.
Yes.
Let me get the exact language. Well, the B3 exception. Do we have in this case the consent of an addressee or intended recipient of the communication?
We don't. We neither have a valid consent nor an addressee or recipient, because at the time the subpoena was issued, the person who is issuing the subpoena is neither an addressee nor a recipient of the information and therefore cannot give valid consent. It is simply illogical to say that somebody who doesn't have access to something can consent to its disclosure. It doesn't make any sense.
I've lost the key to my house and can't get in. I don't have access to it. Can I still, decide whether?
You, as the owner of the house, you have the authority to access that house. That is not true here. This was a message that was sent to the defendant and was intentionally, by the intentions and the privacy expectations of the sender, expunged from the record 24 hours later. If they had access to the information.
Suppose this were not a case in which the communication was, was expunged after 24 hours, though the recipient may not have it anymore for other reasons, and is seeking to obtain it. Would your answer be different?
No, but
Would this be a
Facebook.
case governed by B3?
No, but Facebook, well, if they have the authority to access it and they've given valid consent and demonstrated to Facebook that they have the authority to access the information and give their consent, then Facebook would likely turn it over. So that's
Well, why isn't
within
that
the
ca-
exercise
Why
of
isn't
discretion.
that the case here?
For-
The defendant says, look, I am an addressee on this communication. I was also the intended recipient of it. In fact, I did receive it. And I'm consenting to your turning it over.
For a number of reasons. One, defendant would not be here if they had access to the information. If defendant has access to the information they're seeking, they wouldn't be subpoenaing
There's
Facebook.
nothing in here about access. There's nothing in B3 about access.
Well, that's correct, but
Addressee
recipient,
or intended recipient.
that's correct, but the ability to give consent to access something assumes that you have access in the first place. And that's what the California Supreme Court discussed in Hunter when they talked about people who had received the message because it was sent out to the world as compared to people who didn't. And that's what we have in this case. Granted, it's time-based rather than people-based, but it is still part of what the sender expected when they sent out this message. And at a minimum, the sender should be here answering these questions. And we would request that this court lift the gag order, let my client try and talk to the sender, see if they can get consent, talk to the government, as we would do in any other case, and potentially resolve this issue without the need for a ruling that, frankly, I'm concerned would misconstrue the statute and open up service providers to a lot of things that Congress didn't intend.
Would we have to alter the court's order, the trial court's order, in order to do that? That is,
The trial,
doesn't it require you to produce it? And lifting the gag order wouldn't relieve you of the obligation to produce it?
well, I suppose this court could put a ruling on that issue on hold and stay that part of the court's production order while lifting the gag order and let a week pass and see if we're able to resolve the issue. And then if we're unable to resolve the issue, we could then inform this court and this court could rule on the production order. Thank you so much for
Counsel,
your time.
thank you
Your
all.
Honors.